Good afternoon. Thank you for the invitation to speak to your national seminar on science in the courtroom, examining forensic evidence, and with a particular emphasis from my perspective to talk to you about the role of judges in gatekeeping unreliable science. It gives me great pleasure to speak to you today, and I hope that what I might speak to you about might prove to be of interest and of assistance to you all. I think that a number of things that I will talk about now are really matters likely to have some application or some relevance to the use of forensic evidence generally, and really should not be regarded as being specific to one country or the other. So without any doubt at all, forensic evidence can in some cases make all the difference to whether an accused person is convicted or acquitted of a charge before a court. And I'd like to share some of our experiences in my home state of Victoria in Australia. And to that end, I might start by saying that here we regard forensic evidence as extremely important to get right. To that end, there are a number of accepted ways in which forensic evidence can be examined and what steps can be taken to the point of its actual use in the courtroom. Critical to adducing or challenging this kind of evidence in the courtroom really are a number of matters, which include having sufficient or adequate understanding of the particular topic in question, or having the financial funding to properly investigate the topic, and having the opportunity through the court system to be allowed to challenge the evidence if that is required in the particular case that you're litigating. Before I move on, I was just going to say a little bit about my own experience. I'm a reserve judge in the Supreme Court of Victoria. It's effectively the highest court in Victoria. The sort of cases I do regularly and sit on would be murder cases, manslaughter, very serious drugs, very serious fraud cases, and in some instances, of course, cases involving sexual offending, and a lot of cases involving mental illness, which is a big issue that we have in many of the cases that we do. So far as our system is concerned, to give you some context, which not all of you might currently understand, we, of course, like yourselves, have origins in the British system of justice. We've adopted the basic procedures of English law. We are a federation with Commonwealth jurisdiction over particular matters, but otherwise a number of state jurisdictions where local laws apply. But of course, all states' legal systems are ultimately subject to the supervision of the High Court of Australia, which in the end is the highest court once we decided to give that court the highest jurisdiction. We have in our criminal justice system very strong procedural rules, which are highly established and, of course, are a mixture of the common law, but also supplemented by our local Criminal Procedure Act in Victoria. Like yourselves, the adversarial system is the key part of our judicial process and criminal justice system. We have a Uniform Evidence Act, which now applies similarly across the whole country, with some variations within states. We have juries, and in serious matters, for instance, taking the example of murder in Victoria, which, of course, the sort of cases that I'm involved in on a regular basis, in this system, because we have juries, judges are the umpires. We are not entitled, in cases where there are juries, to make findings of guilt. The decision of a case and the outcome of a criminal trial is entirely in the hands of the jury. And of course, unlike judge-alone trials, which we have had in Victoria at times during, for instance, the COVID pandemic, when we just had to get on with work, where the government gave us an opportunity to do some judge-alone trials. There, of course, as a judge, you have to give strong reasons and reasoned decisions. With a jury, no reasons are given. The arguments are made to the jury, they go out and deliberate, and in the end, the verdict that's given is either guilty or not guilty, or in some instances, of course, we can't make our mind up. Our court procedures are very established, and we typically run our cases on the basis that both Crown prosecutors and Defence Counsel have opportunities to address the jury with opening statements before the evidence begins. At the end of the trial, both sides sum up their cases and make their arguments to the jury, and then the final point before the jury goes out to deliberate is that the judge sums up the case. And I would give the jury a mixture of legal directions as well as a discussion of facts, a discussion of the issues of the trial, and try to relate the issues of law that they have to decide. I thought I would begin, because I have some experience in prosecuting cases, to tell you a little bit about the prosecuting approach to the way in which we conduct our cases in Victoria. I might say that as the Director of Public Prosecutions in Victoria, where I headed the service that I've described to you, that Public Prosecution Service prosecuted all of the serious crime in Victoria, apart from those matters the Commonwealth DPP might prosecute. The prosecution in our system is really the key part of the system. Prosecution drives the system. Without prosecutors bringing cases to the court, there's nothing to try within the criminal justice system. The prosecutor files indictments, and typically the practice is that the prosecution provides to the defence or the defence of the particular subject who has been accused what we would describe as a brief of evidence or a hand-up brief. That brief is compiled by police investigators, and then once the police have investigated the matter, the brief is provided to the prosecution service, and then we ensure that the defence have the brief and gets the matter, of course, then is prepared for trial. I think a key point to remember is that the Public Prosecution Service in Victoria are not investigators. We don't investigate cases. That's the role of the police, and there is a bright line between the police investigators and the prosecutors. It's not to say we don't talk to each other. There's a very close association between the two, but there is a line that's drawn between the two agencies. One of the matters that I would regularly talk to my staff about is to remind them that in our system, prosecutors are not at war with criminals. And it's important to understand that the role of a prosecutor for us is not to unfairly strive for a conviction, but to always act fairly and impartially, to present all of the relevant evidence and then let the jury decide. And as I'm obliged as a judge to tell a jury in my legal directions, the defence have to prove nothing at all. The defence can sit back and let the prosecution prove the case. But as I said, prosecution, we are not at war with criminals. We are there or prosecutors are there to present the case impartially and fairly. And that's an extremely important principle that we abide by in this country. And above all, it's a vital part of the prosecuting process that the prosecutor must not put aside or hide or bury evidence that might be regarded to be of advantage to the defence. But if that evidence is relevant and may be of assistance to the defence, it must be called as part of the prosecution case. Now, a number of people wonder why that's the case, because they think there are two sides and one side pitches itself against the other. It's not a case in our system of doing that and choosing one side against the other. The burden of proof always remains on the prosecution. And it is fundamental to our process that the prosecution must act fairly as model litigants with the objective of ensuring just outcomes. And this approach is accepted as fundamental to our criminal justice system and is a highly regarded principle. And we indeed have to remain vigilant to ensure that this principle is complied with. And I think some lawyers do struggle with the idea that if a prosecutor finds a piece of evidence that might be helpful to the defence, well, why on earth should we give it over to the defence? Well, that's our responsibility. And the responsibility is to call all of the evidence, call all of the eyewitnesses that are required. And then if the arguments are all produced at the end, and prosecutors are entitled to argue for whatever the witnesses they call one way or the other, either accept this witness or disregard the evidence of that witness. So let's talk a little bit about the role of expert evidence. Expert evidence can either be contested or not in front of a jury, and quite often it's not contested. But I have to say that in the assessment of that particular issue about whether or not it will be contested, careful decisions are made about whether it will be or not by both sides and prior to the trial process. For instance, a prosecutor will want to know if the evidence that he or she is going to call is reliable and can be safely relied on. And similarly, the defence will make an assessment of the probative value of the evidence and will react accordingly. Probative value is the fundamental requirement of admissibility under our evidentiary rules. If it's not probative, it's not relevant and it shouldn't be called. So the question ultimately under our Evidence Act, which is Section 55, is the evidence relevant to a fact in issue, and it assists the jury or the fact finder in the determination of that issue. If it's not probative or it's not relevant, then it's inadmissible and should not be placed before the jury. And we're quite rigorous about this. In our system, the examination of expert evidence in a case is carried out transparently and with full opportunity for all parties to assess it, and they do that. The opportunity is fully accepted by all of the parties and the stakeholders in the system. And that, of course, means that we have to have full disclosure of the evidence. And full disclosure means full disclosure. If necessary, the methodology of the expert can be examined, and that's with some application easy to follow through with a full examination. Forensic experts are expected not to stand in the way of this, and often forensic expert evidence, like most other people, want to talk about their work, and they want to explain why their work should be accepted. So one of the areas in which this can be done is by obtaining the working files of the working results of the experts, meeting with the experts, finding out why and how they came to their decisions. And all of that is possible. In our system, there is no property in witnesses. Any defence barrister can ring up a government forensic scientist or a government forensic pathologist and have a conversation with them over the telephone, or go and meet them, have a conference with them and discuss the evidence. Just picking one example that might be useful to talk about, causation of death is a good example of this area. And in most cases, as you'll all understand, causation is clear. A bullet wound to the head or a single stab wound to the heart, for instance. So in those situations, causation is often not a matter that's contested and run as an issue in a case. But in some cases, the evidence pointing to causation itself, its quality or the relevance of it, is heavily contested. For instance, did the assault actually cause the death of the victim, or did he or she die from their pre-existing heart condition? So there can be a compilation of factors that need to be considered. But in the end, the question's got to be answered as to what's the causative or the operative factor or factors that contributed to death. Was it the criminal act that ultimately led to the death of the particular person? Now, normally, expert forensic pathologists will give evidence about this in front of a jury. But if necessary, then what will happen is that before the expert gives evidence in front of the jury, the expert can be cross-examined at a preliminary hearing before the empanelment of the jury, or otherwise in the absence of the jury, to see what the evidence amounts to and what it is capable of proving. And here's the importance of that process. The process is a transparent one, where if the evidence is ultimately of doubtful value or of relevance, then an application can be made, firstly, for the prosecution to discontinue the case. if the evidence turns out to be not valuable and if it's a major or a main plank in the prosecution case, it may be so equivocal to justify a discontinuance of the case. And this is a very important option that is taken quite regularly with the prosecution. Simply, what would happen is that the accused person's representatives would make an application directly to the Director of Public Prosecutions to discontinue the case on the basis that it is going to fail. And the prosecutor in our jurisdiction has very strict policy about this. There's a two-part prosecution policy. The first part being the question that needs to be answered: is there a reasonable prospect of conviction? And if there is, the second part of the test: is it in the public interest to pursue the case? And those two questions have to be asked. And if it's in the end the director determines there's no reasonable prospect of conviction, the case will be discontinued there and then. If the question's answered in the affirmative and there is a reasonable prospect, then of course the director needs to consider whether or not there's a public interest in pursuing the case. And there are many cases in which it is not in the public interest to pursue the case further. So moving back to the preliminary proceedings, for instance, in cases of DNA evidence, there can be pre-trial hearings where the evidence is examined and the arguments about admissibility can be made, leading to judicial rulings about admissibility or inadmissibility. And in some cases, the evidence will be excluded from admission in the trial. But the important point is that this all happens before the jury is impanelled. And so rulings are given prior to the impanelment, or in some cases where the issue might arise whilst the jury is in fact impanelled, arguments will happen in the absence of the jury and rulings will be made, and then decisions will be made about it. And what is important here is that the evidence in its written form is provided to the defence and the prosecution at the early stages of the preparation for the trial, so everybody can understand the evidence and should know what it amounts to on paper. So this means there must be strong disclosure of the prosecution case and the evidence that supports it. And then there, of course, is the opportunity for full scrutiny of the evidence, and importantly, to allow for the opportunity for defence forensic experts to also examine the quality of the prosecution evidence and any opinions offered, and be able to research these issues as widely as possible, and then contribute to whatever pre-trial argument might be mounted to persuade a judge to reject the evidence on the basis that it is inadmissible. So all of that can lead to things like the scrutiny of the forensic science laboratory, and that might, for instance, try to examine whether the processes have been compromised or contamination may have occurred within the laboratory, either in a particular case or systemically throughout the organisation. And under our rules, and without getting too technical about it, judges can in some cases rule evidence inadmissible if its probative value is outweighed by its prejudicial nature. And that will be a matter for the judge to determine, as I said, prior to the leading of the evidence. So all of that is a part of the process of strong pre-trial management, where the judge has strong powers to direct the procedural course of the proceedings. Now, we are not in a position where we would proceed with the trial and then make rulings after the trial is over. Evidentiary rulings are typically held before the trial starts, or in running if it's necessary because something emerges that's a surprise, not after. Although rulings may be published later after they are perfected, the decision and in-running oral reasons for a ruling are often made during a trial process. But both sides get to argue the point and have the decision made before the evidence is led or not led, depending on the outcome of the ruling. And importantly, a pre-trial ruling that's well argued might result in a change of plea, so that an accused person decides, now that I know what the evidence is, I don't think I can win this case. So it might result in a plea of guilty, either to the main charge or an alternative lesser charge, or indeed, as I said, it might lead to a discontinuance if the evidence turns out to be of typically poor quality. Now, the procedure for pre-trial rulings is enshrined in our Criminal Procedure Act. A judge can make pre-trial rulings and rulings about matters that are in fact anticipated to arise in the trial under Section 199 of our Act, but also the judge has, of course, just simply the power to hear any matter by way of pre-trial ruling to decide these things before the trial starts. The reason for this is that once a jury is impanelled, there's no stopping the trial. It then runs, and that could be a trial that lasts a week, 2 weeks, or 6 months, or even longer, depending. But there's no stops on the way through, except if there's major public holidays and illnesses and things like that. So this is all underpinned by the importance of disclosure. And in my jurisdiction, we act on the principle that there must be full disclosure of the prosecution case. And that's provided for by a combination of established common law principles, but supplemented by our legislation in the form of the Criminal Procedure Act. So it's thus accepted that that is our system, and the principle of disclosure is fully accepted. Whether or not something is disclosable and relevant, of course, is a matter of judgment and up to individuals. There's got to be a limit to disclosure, and it's got to be about matters that are relevant to the case. You just don't disclose every case in the world, but it's about material that's about the case that is expected to be disclosed. And of course, disclosure is a matter of judgment and up to individuals, typically to begin with, police officers or investigators who decide what is going to be disclosed to the prosecution agency. And then, of course, the prosecutor has a separate duty of disclosure as well. If the defence thinks that disclosure has not been properly attended to or complied with, there's a remedy, and that remedy is that there will be a call for the evidence to be provided, a formal call. It can be made in court, or if it's prior to the court hearing, by using the process of subpoena. And the subpoena, properly constructed and properly put together, really is designed to get any undisclosed evidence to the court so that the court can make a judgment about whether disclosure is complete or incomplete. So just to talk about disclosure, in Victoria, we are governed by the disclosure provisions that are clear. The role of the prosecutor is to provide all of the evidence and must disclose evidence to the defence that is regarded as helpful to the defence or may point to a line of inquiry that might assist the defence. We all live with that. We all accept it, and that's the rule that we work with. Now, let me move on a little bit to talk about expert evidence in criminal trials, and I want to talk to you a little bit about our Supreme Court practice note that we have developed in Victoria. A practice note in our court is a document prepared by the court and authorised by the Chief Justice, to which litigants in the court must comply with. And often practice notes are about procedure in the court, and they are designed to set standards that the parties must comply with. We have an expert evidence practice note which arose really as a result of two particular Victorian cases. One case was a case of Klamo, K-L-A-M-O, which was a baby shaking case, which was litigated about a decade or so. It was a manslaughter case, and it resulted in an outcome that in the end was overturned in the Court of Appeal. The other case that is relevant for us is the case of Farah Jama, J-A-M-A, which was a rape case. And in that case, DNA was particularly important. And in the end, in that case, contamination was established in the particular laboratory, and resulting in the end in no proof that the accused was at the scene of the particular crime. Now, they're very simple explanations of those cases. Both cases were adjudged by the Court of Appeal to be miscarriages of justice, and people were set free, having been convicted in the lower court and jailed. In the baby shaking case of Clarmo, the miscarriage came about as a result of simply the right questions not being asked about causation of death at the trial. No one asked the right questions, and the forensic pathologist really had no ability to be able to say, hey, you haven't asked me the right questions, because a witness, of course, is governed by the questions and answers and the people asking the questions of them. And as I said in JAMA, contamination was ultimately established at the point that the case was in the Court of Appeal. So ultimately, to cut a long story short, that resulted in the formation of what we've called the Supreme Court Forensic Evidence Working Group, from which the practice note was developed. And it was developed really at the instigation of two main people, one being Professor Stephen Cordner, a world famous and well-regarded forensic pathologist, who was the pathologist in the Clarmo case and who said, I've not been asked the right questions. And the other being the now retired president of our Court of Appeal, President Chris Maxwell, who has talked a lot about these issues and particularly the reliability of evidence. So the Expert Evidence Working Group was formed. I was part of that as the DPP, and I sat on it, and it still exists. And in fact, I've now become the chair of that particular working group. So I've come full circle from that point of view. So in the end, the Expert Evidence Practice Note is a document that is designed and its purposes are set out for these four objectives: to enhance the quality and reliability of expert evidence relied on by the prosecution and the accused in criminal trials, to encourage the early identification of issues in dispute, which will be the subject of expert evidence, and the improvement of the utility of expert evidence by ensuring that it's focused on the issues genuinely in dispute, and to make use of existing pre-trial and trial processes at the earliest practicable opportunity to advance those purposes. There are a couple of key issues, I think, that are spoken about in the practice note, and one is to remind us what the expert's duty is. And the expert's duty is to the court. The expert has an overriding duty to assist the court impartially by giving objective, unbiased opinion on matters within the expert's specialised knowledge. And it overrides any obligation by the commissioning party or to the person by whom the expert is paid. That's a fundamental rule. So the expert is there to assist the court processes. The expert, of course, the duty is to also include the obligation to inform all parties and the court promptly if and when the expert opinion changes from that contained in any report served as evidence. Importantly, an expert evidence is not an advocate for a party, even when giving testimony that is necessarily evaluative rather than inferential. The practice note goes on to talk about the content of expert reports, and this was something that Professor Cordner was very passionate about because he came to the Expert Evidence Working Group with the aim that some guidance should be given to experts to as to the right questions that will be asked. So the practice note sets out a whole series of questions and issues that must be addressed in each of the reports. So that should be of enormous assistance to experts and to try and at least standardise the approach of expert reports. The practice note then goes on to talk about primary expert reports and responding expert reports, ensuring that everyone has full access to materials and that the defence in particular have full access to the workings of any experts, of any examinations, measurements, tests or experiments as to findings and so on, and anything on which such examination, measurement, test or experiment was carried out on. The practice note then goes on to talk about the availability of expert reports to other parties, so it ensures that expert reports must be provided in good time before a trial starts, and that's a very important feature so that no one is caught by surprise. No more reports at the door of the court on the first day of the trial. it's important that everyone knows what the reports are going to be before the trial starts. So everyone has an opportunity to consider it and litigate it in pre-trial argument if that is the case. Now, one of the features of the practice note, of course, is also to adopt the principle or the practice of what we call consecutive or concurrent evidence. So I'm not sure whether everyone might have heard of the description of hot tubbing, but we are, in some cases, entitled as judges to direct that experts talk to each other. Defence, prosecution experts get together in a room, talk through the issues and try and refine what the issues are that are going to be litigated. And then further than that, the court can direct that those two experts, either on the basis that they remain opposing each other, may in fact get into a witness box together and give evidence at the very same time. So that all assists the court with having the evidence in a format that a jury might be more easy to understand, and for experts to try and refine what the issues are. And finally, I think two other things that are worth mentioning that as additions or annexures to this expert evidence protocol or practice note is that there are annexures item 1 and item 2, the first being in the area of forensic pathology, which provides a list of standard questions to address as to the cause of death in an alleged homicide. 11 questions are set out, and the forensic pathologist is directed to consider each of those questions in what they're doing and what they report on. And the second item is about adult sexual assault, and that again sets out a list of 13 questions that a pathologist or an examiner in those areas is required to consider, and under the heading of the significance of genital and other injuries or their absence. So expert evidence, we hope, is managed in a logical and an open way in Victoria. It's directed towards, through the Supreme Court practice note, hopefully an assurance of quality and a standardisation of statements. And in this regard, we believe that Victoria is the first state in Australia to have achieved this. And I think the practice note is useful as it sets standards that are expected by the court and readily understandable by the prosecution and defence. And it poses particularly issues of guidance on the use of expert evidence. Now, I think that's probably all for the moment. Thank you very much for listening to me. I wish you a very good conference.